government has more interest in prosecuting these crimes than the tribal government. When a tribal citizen commits a crime, the sovereign government that has the most interest in prosecuting that crime is that tribal government. Would you say that when a citizen of Kansas prosecutes a crime, that the state of Nebraska has a higher interest than the state of Kansas? No, you would not. And so McGirt, again, affirms and upholds this principle of the government on the ground has the most interest, the highest interest. And let's affirm and let's hold up their jurisdiction and authority to address these crimes. That's what McGirt is about. Now, how does this relate to safety for Native women? If you look at the Supreme Court's decision in 1978 in Oliphant, in 1978, the Supreme Court issued a devastating decision saying, you know what? From this day forward, we're removing tribal jurisdiction over non-Indian crimes. When non-Indians, and this is not McGirt, right? McGirt wasn't Indian, but when non-Indians come onto tribal lands and commit crimes, they do so with impunity because tribal nations do not have criminal jurisdiction to prosecute them. That's Oliphant. Had devastating impacts on our tribal nations. Today, Native women are more likely to be raped, killed, murdered, assaulted, abused than any other population in the United States. The majority of the individuals committing those violent crimes are non-Indians, but the Supreme Court has taken away tribal jurisdiction to prosecute those crimes. All of a sudden, though, in 2013, Congress, in reauthorizing the Violence Against Women Act, restored a category of non-Indian perpetrated crimes against Native women and girls. And that category was domestic violence and dating violence and violation of protection orders. Huge victory in VAWA 2013. But that restoration of tribal criminal jurisdiction was limited to crimes committed in Indian country under 18 USC 1151. What does that mean? That means that if Muskogee Creek Nation has implemented VAWA's restored tribal criminal jurisdiction for domestic violence crimes committed by non-Indians. But had Oklahoma won and convinced the United States Supreme Court to, first of all, reverse course on the last 100 years of precedent, making very clear that only Congress can disestablish a reservation created by treaty, but had the court bought Oklahoma's argument and done that, then Creek Nation would not have a reservation. And under 18 USC 1151, the only places within Creek Nation's borders that would be Indian country under that federal statute would be land that remains in trust. What does that mean? That means when that same Native woman on Creek Nation's lands calls 911, calls Lighthorse and says, help, I'm being abused by my non-Indian spouse in my home, and I need you to come protect me. Tribe, the Creek Nation would not have jurisdiction to prosecute those crimes, those domestic violence crimes committed against that Native woman, unless they could prove that the land in which she was being abused on was trust status land, was in restricted status, and was not non-Indian fee land. And we all know how large portions of lands within Oklahoma are no longer in trust status. All you have to do is look at the history, look at the movie Killers of the Flower Moon that's coming out soon, made by Martin Scorsese, that documents the history of murder of Native people to get their lands, their head rights, their assets. At the turn of the 20th century, there was a huge movement through the Oklahoma courts, through corruption, through fraud, through federal Indian agents to take Indian land and put it into non-Indian ownership. So most of our reservations today in Oklahoma are over 90% owned by non-Indians. They're non-Indian fee land. And so that means that for issues related to safety for Native women, maintaining reservation status for Cherokee Nation, Creek Nation, Choctaw Nation, Seminole Nation, these tribes that have implemented VAWA's restored tribal criminal jurisdiction, maintaining those tribes' reservation status is critical to maintaining the ability of tribal police and tribal attorney general's offices to prosecute any domestic violence crime committed by a Native woman within those reservation borders. Because if you lose reservation status, you're losing jurisdiction over about 95% of the land when it comes to prosecuting domestic violence crimes committed by non-Indians. So I hope that answers the questions you sent me and provides a helpful overview. I know that was pretty fast.
I gave you quite a lot to do in just 13 minutes. So that was a really good overview. And thank you so much. I know we're going to go to Judge Leeds next, but hopefully we'll have some time at the end where we can kind of, come back to some of those points and answer anyone's questions. So good afternoon, Judge Leeds. I just want everyone to know how amazing you are. You're currently the Dean of the University of Arkansas School of Law. Is that right? Or
No longer.
No longer. Dean Emeritus. I'm so sorry.
No
and also a judge in tribal court in Cherokee Nation. And so you do so many amazing things, and we're just so lucky to have you here talking with us about these critical issues that face our state. And I just wanted to say thank you so much, and ready to hear from you.
Great. Well, thanks for the opportunity to be here with you all today. I'd like to start off just with a quick introduction of where I'm sitting. I am at the courthouse right now for the Muskogee Creek Nation, and I am one of 3 district court judges here. I, like Mary Catherine, am a citizen of the Cherokee Nation. So I'm the only judge here at the Creek Nation who is not a tribal citizen of the Muskogee Creek Nation. And right now there's 3 of us that hear cases. There will be a 4th judge appointed soon, but I predominantly hear the civil cases that come before the court. But I will occasionally hear some of the criminal cases if there's a recusal where one of the other judges has a conflict of interest, or if there's a calendaring issue that requires that some of those cases be onto my docket. We're talking about McGirt cases that could come before the Muskogee Creek Nation, but I'd like to talk just generally. And the questions that were posed to me speak to what McGirt means for the future of crime and crime prevention in Indian country. And, there's a lot of talk about McGirt, but McGirt lives in a universe of a lot of Supreme Court cases and a lot of federal statutes that govern who responds to law enforcement inquiries, what courts would hear a case, what prosecutors would be the ones to initiate those cases in the courts. And so I would like to highlight that in addition to the McGirt case, which was decided in July 2020, there has also been another important case about Indian country criminal jurisdiction that was just decided by the United States Supreme Court in June of 2021. And that's the Coulee versus United States case. It dealt with a crime that happened in Montana on the Crow Reservation. And so I want to talk about McGirt and Coulee as a tag team, because I think that it helps parse out for all the confusion what happens on the ground when there's a law enforcement called out to a crime scene, and then how the decisions that happen after that all play out. And so you've heard quite a bit about McGirt, but to summarize it down to the bare bones, McGirt decision states that Oklahoma lacks criminal jurisdiction over major crimes that are committed by Indians inside of Indian country. And you've heard mention of this federal statute called the Indian Country Statute, which is 18 USC 1151. And so after McGirt, cases that involve Native Americans will be prosecuted by the federal government and or the tribal government, but no longer by the state of Oklahoma. And that case applied when it started out only to the Muskogee Creek Nation, but it was understood at the time that it would eventually apply to more tribes. And that case was only applied dealing with major crimes such as murder, rape, child abuse, arson, those types of major crimes that are spelled out in a federal statute called the Major Crimes Act. But it was understood at the time that the crimes committed in Indian country on a reservation, there's a whole series of laws that apply to determine who prosecutes those cases. So it puts Oklahoma in the exact same camp as most of the Western states where there are Indian reservations. The Coulee decision states that a tribal police officer has the authority to detain and arrest a non-Indian defendant on suspicion that that person violated either federal or state crimes. And they can do that basic investigative work, and they can ask questions, search a vehicle if necessary, do the kinds of things that law enforcement typically do when they're called out to a crime scene. Now, in Coulee, the officer initially involved in that case was a police officer that was employed by the tribe. And it was the federal government that eventually prosecuted the drug charges and some firearm charges that came out of that arrest. But the reason being is that, as Mary Catherine mentioned, back in the late 1970s, the United States Supreme Court decided a case called Oliphant. And it was determined at that time that tribes lack the authority to prosecute non-Indians for crimes that are committed inside that tribe's territory. So everyone understood in that Coulee case that the tribe would not be the prosecuting authority in that case. Only the federal government or the state government would be the one to prosecute that case. Now, Congress has come back in after that Oliphant decision and crafted one very narrow exception when it will be okay for a tribe to prosecute a non-Indian, and that is for crimes where it involves domestic or dating violence only. But for all of the rest of the crimes, if the defendant is the non-Indian, the tribe has no prosecutorial authority. And the question would be, where does this crime go? Does it go to the state or does it go to the federal government? And so I'm going to deal with what crimes get prosecuted in the tribal court versus the federal court. Now, tribal prosecutors generally cannot prosecute non-Indians. You know that now. They can, however, prosecute people who are tribal citizens, either of that particular tribe or of any tribe, so long as the tribe's reservation boundary is where the crime happened inside of. The United States Attorney can also prosecute people who commit federal crimes. So there has to be some federal statute that you would charge that person with in order for that U.S. Attorney to proceed. And so there's lots of them. It involves in something called the Generals Act, which basically says where a crime happens in Indian country, inside a reservation, and a Native American is involved, then the U.S. Attorney would have the right to be the one to prosecute that case. But there's also many, many criminal federal statutes on the books. And if there's something that you charge the person with, then the U.S. Attorney can proceed. Now, most of the people on the call here today are Oklahomans and of a certain age where you will all remember Timothy McVeigh and the Oklahoma City bombing. And I think that that's a good example to help us walk through kind of an intellectual exercise here. So let's do that. Timothy McVeigh killed 168 people. And if you'll recall, he was executed by lethal injection in a federal prison out of state. And at the time he was initially arrested, he was arrested by an Oklahoma State trooper up in Noble County. And he was arrested by the state, but he was eventually indicted on 11 federal counts, which included conspiracy, weapons of mass destruction crimes, crimes that deal with explosives. But he also was charged with 8 murders, and those were federal officers that he killed. And the reason that I want to bring that up is that no one in Oklahoma would presume that the state wouldn't have authority, right? That was in Oklahoma City. It happened in Oklahoma. And it absolutely was the case that Oklahoma County could have brought 160 plus murder charges against him. So that would have been the Oklahoma jurisdiction piece of it. But there was also the federal jurisdiction piece of it. And that was ultimately what he was convicted and sentenced to die in that federal court. So it's an example of, yes, one officer makes an arrest, but then there is the possibility in that case of both federal crimes and state crimes. And so that's essentially what happens now after McGirt, right? Anybody who is an officer under the law who can arrest that person makes the decision based on public safety to arrest that individual. That person gets booked into a jail, and then we ask the question, now which courts have the jurisdiction to hear the case and what prosecutors have the right to file charges, right? So if it's in Oklahoma and it involves 2 non-Indian people, Oklahoma will hear those types of crimes like they have forever. But where a Native American is involved, now you have a crime that took place on an Indian reservation that involved Indian people. So just like the Timothy McVeigh example, we have somebody sitting in jail, and now there's going to be decisions about where crimes get prosecuted, right? So if it's a federal law that can be charged on this person, then there's going to be a U.S. attorney that decides whether they're going to bring federal charges. If it's a Native person, the interesting thing is that the federal government can probably prosecute them for a crime, but the tribe might also be able to prosecute them for that crime. And so there's a decision to be made about which one goes first if they both can go. And what tends to happen on the ground is if it's the more serious level crimes, like the murder charges, the rape charges, the child abuse claims, the U.S. attorney has more resources than the tribal prosecutors do. And so in most of those instances, if there's the ability for the federal government to be the one to bring the charges in federal court, that's probably what's going to happen, right? Those prosecutors are going to talk to each other, the law enforcement's going to talk to each other, just like in that Coulee example, and the feds are going to prosecute. But there will be times where either there's not enough evidence and the U.S. attorney doesn't think that they should move forward with the case, or there might not be a federal statute that can be charged on that individual. Then the tribe will look and say, okay, is this a case that the prosecutor decides that they want to move forward with? And under the law, could have been charged for both the federal crime and the state crime. If someone commits one of these crimes in Indian country today, they might, as a Native American, be able to be charged by both the federal government and the tribe. And there's no double jeopardy concerns because both the federal government and the tribe get their power to prosecute from their own sources of law, okay? And so that's basically how the distinction goes. Now, if I can go back to prosecuted that person because who was arrested on a highway running through the reservation. But that tribal law enforcement officer did what law enforcement officers do all the time. He started talking to the person, trying to gather some information, trying to assess the situation. Is it something that is a security threat that I need backup for? Right? And as he talked to this individual, not only could he look into the vehicle and see some guns and a small child, but as he continued to question the individual, just none of the stories were shaking out. And so what eventually happened is that person was arrested by the tribal police officer. The car was searched. There were drugs and guns found in the car. And so that individual was detained, and then the other law enforcement were contacted. And so the federal law enforcement who eventually gave the police reports over to the U.S. attorney so that they could eventually bring charges. The challenge in Coulee was if that tribal police officer couldn't hand over that information to the tribal police prosecutor and have that claim be brought in tribal court, then what happens to all the evidence that was collected at that crime scene? And so in the federal prosecution of those cases, the defense counsel said all that evidence should be thrown out. It should be thrown out because it was a tribal police officer and not a federal FBI agent who took that information, and all of that should be thrown out. And the United States Supreme Court said no, right? Governments do what governments do. Law enforcement does what law enforcement does. And it would be inappropriate to throw that out for that federal conviction just because it was another kind of law enforcement officer who questioned and then ultimately took possession in terms of seizure of that evidence from the car. And I think that Coulee is really important for us in Oklahoma because in the Coulee case, there was no cross-deputization agreement. This was just a tribal officer who was responding to what he assessed in his law enforcement background and training was a threat to the public, right? That was a situation that was escalated and he had to do something. He couldn't just let the person go. And if he was out there by himself and didn't have backup, he needed other people to be, reached out to. So whether that was other tribal law enforcement or state or federal law enforcement, he did what was necessary. And then we take all of that circumstance, and when we decide what the proper authority to prosecute would be, all that gets handed over to that prosecutor's office and they move forward. Well, here in Oklahoma, we have an unusual situation because we have so many cross-deputization agreements, which means that the tribal and federal and state and county and university and city police officers, most of them, particularly in Cherokee and Creek Nation, I'll speak to those two in particular, there are all these law enforcement agreements that basically say, you know, if there's a 911 call or you drive up and you happen upon a situation, you do what you are supposed to do with your law enforcement training, and we will sort it all out later whose court it actually gets prosecuted in. And with these kinds of agreements, basically all of these jurisdictions are sanctioning each other to make those first initial law enforcement actions and then hand it off to the other individuals. So I actually think that in Oklahoma, even before McGirt, we were a lot further down the road in terms of these law enforcement arrangements than what we see in other places throughout Indian country. And then McGirt happens, and all those were already in place. But what that tells us is now we need to really up our game, and there needs to be more cross-deputization agreements and more communication and cooperation between law enforcement, because there's going to be so many more instances now where that evidence gets handed over, or that testimony of one officer in another court might be called upon. So I guess as the takeaway in this, I want to say that, you know, McGirt was very important for tribes because it reinforced longstanding arguments that they've made about their own jurisdiction and their sovereignty. But I think that every single tribe that is implicated in these decisions as of late, they have absolutely the same safety concerns as everybody else does. They don't want crime in their communities. And so as much as it was a win for the tribes, I want everybody to take a pause and realize that the tribes are just as concerned about the rights of the victims and making sure that all of this works out well. And they have a really high stake in making sure that that happens. And so I'll end my part of it by just simply saying that the large tribes here in Eastern Oklahoma, they all have victim services offices. And I know that if you're not familiar with tribal offices and tribal governments, that might be a daunting task to try to figure that out. But they are there and they will serve victims, whether they're Indian or non-Indian, if the case is filed in that court. Now, the other thing that I want to say that's very frustrating, but we're continuing to work on it, is that from the perspective of a judge, I hate sports analogies, but I'm going to make one, right? Oftentimes the court and the court clerk has no idea what's going on in the field, right? The judge only gets involved if there's a case that actually gets filed in that court. And so I know that there's a lot of confusion about who to contact, who not to contact, but if you reach out to one of the tribal courts, they can only tell you whether there's an active case that has already been filed in that court. They can't tell you whether someone was arrested and who arrested them and all of that type of thing, because that doesn't come to the court until later. And so we always like to say that it's like baseball, right? And the court is the person who's up to bat. But until there's been a ball and it's been pitched to that court in the course of a case number, the court doesn't get involved until pretty long down the road. It's those rubber meets the road law enforcement people who are making that first, action. And then whether someone gets booked into a county jail, none of the tribes here have their own jail systems. And so right now there's contracts where the tribes are paying the counties to hold someone in pretrial. And then there has to be a decision made. Is the U.S. attorney going to prosecute? Is the tribe going to prosecute? Or is this one of these situations that stays with Oklahoma, like most of the cases after McGirt? And so on the ground, there'll be that determination as to which direction that case is going. And then it starts the ball rolling in that particular criminal justice system. So with that, I'll yield the rest of my time and we can do questions. And I'm happy to entertain any of those when the moderator says it's.
Thank you so much. I love the analogy that you used between, the Oklahoma City bombing and McGirt, because I think a lot of people get really confused and think that things can only be prosecuted in one place, and it has to be. But we have the dual sovereign or the multiple sovereign doctrine that says it's not double jeopardy if you get tried in state and in federal, and so, or in tribe or in federal. And so I think that's something that can be concurrent jurisdiction can be really confusing if you aren't a lawyer or you don't understand that, like, things can happen in multiple systems at the same time. So we're going to move to Casey Baldwin. She's a public defender in Tulsa County, and she has been given the humongous task of, and taken it on with such zeal, of finding folks who are in DOC in Oklahoma who are tribal citizens and who have been tried in Tulsa County, and helping them file for relief under McGirt if it makes sense for them to do so. And she's also an incredibly successful trial lawyer and just a great person. So thank you so much for being here, Casey. We'd love to hear what you've got for us today.
Thanks, Colleen. Thanks for that great introduction. I am a non-native, but I am married to an enrolled Cherokee citizen, and all three of my children are enrolled Cherokee citizens. So this issue is close to home for me as well. I am the supervisor, as Colleen said, of our office-wide McGirt response. Tulsa County is entirely native land at this point. We are the southern half, south of Admiral, covered by Muskogee Creek Nation, and north of Admiral, we are Cherokee Nation under the Hogner decision. So all of Tulsa County is impacted greatly by this decision. Since July of 2020, last year, when it was handed down, my office has filed approximately 900 motions, which impact, even more case numbers than that. So it is far-reaching here in this county. And so I can speak mostly to the experience that I have here. However, the law that we're talking about is federal law and statewide. So the law is the same, even though how it's practically implemented is going to differ county to county. Colleen has posed the first question to me is, how do you help defendants who think McGirt might apply to them? So I am talking to you as a friend or family member or defendant who thinks McGirt may apply to you. The number one thing that I would say is to help gather tribal documentation. So I will talk right now as the law stands. There are lots of disputes about whether or not the test for who is Indian and who is not should be what it is. I'm going to talk about what it is and not, what it should be. But right now, the law requires that you prove two things. It says that being Indian for criminal jurisdiction purposes it's not based on race. We cannot make laws based on race. That would be a violation of equal protection. Being Indian for criminal jurisdiction purposes is a political classification. So that means that you have to prove not only that you possess a quantum of Indian blood, but also that you have been recognized as Indian by either the tribe or the federal government. And there is case law out there, and the Oklahoma Court of Criminal Appeals has indicated that they're going to follow that case law that requires that you prove both of those prongs existed on the date of the offense. So you must prove that you have the quantum and that you are recognized by either the tribe or the federal government on the date of the offense. As a friend or family member, what you can do is you can help get copies of the individual's CDIB card or copies of the tribal membership card. Sometimes tribes will provide you with both of those things. Tribal enrollment is not the only way that you can prove you satisfy the test for Indian. You can also gather things like records that you went to the Claremore Indian Hospital or the Pawhuska Indian Clinic, records that you received school supplies, clothing, things like that because of your tribal status. So we're looking at benefits that were received that were reserved only for Indians, or voting in tribal elections, employment with the tribe, hunting and fishing and licenses through the tribe, certificates for Indian feathers that you obtain from the tribal agencies. So as a friend or family member, particularly with someone in DOC, you can help gather those documents. You can get those documents to that individual's attorney. The other thing you can do as a friend or family member is help talk to the defendant about whether or not filing a McGirt motion is realistic for them. That's something that I think people are sometimes too quick to jump on the train and file the motion without considering all of the potential outcomes. And that segues into another question Colleen posed, which is generally who should file the motion and who should not, because the consequences might be greater if they do. In large part, I would say my clients who do file the motion to dismiss or the post-conviction relief motion, they are better off. I would say a very overwhelming majority of defendants are better off in the federal or tribal system than our state court system. And we could talk for a whole entire other panel about why that would be, and the things that we need to fix in the state system to make that not the reality. But that is the reality, that an overwhelming majority are better off when they get out of this state system. But there are some that are not going to be. The unfortunate reality is you're not going to know whether you are better off or worse off until you get the ball rolling. So the conversation I have with all of my clients is, once you file the motion, your case is going to be referred to the feds of the tribe. They may choose to file charges, they may not. If they choose to file charges, the charges they may file could be different than the charges that are filed in state court. They could be better, they could be worse. The offer that they give you could be better, it could be worse. So that's something that the client should discuss with their attorney. There are also some tools out there that are really helpful. The federal sentencing guidelines are very fact specific, and they are often a smaller range. So in Oklahoma, you're going to have 0 to life for, child abuse. You're going to have 4 to life for manslaughter. You're going to have these overwhelming sentencing ranges. For somebody who's a third-time offender, it's almost 4 to life on everything at this point, almost. So the federal guidelines are not like that. They are much smaller. And there's a tool online. It's www.sentencing.us, www.sentencing.us, where you can go based on the offense, and then you can choose aggravating and mitigating factors. So that's another way how this is kind of hard to answer. In federal court, there's a base range. So I'm just going to use, 10 years, 120 months as an example. That may be your base range, 10 years, but then you're going to get time added to that if it involves a firearm. You're going to get time subtracted from that if you take responsibility. You're going to get time added to that if you have priors. So you can play around with that tool to try and get an estimate, but it's never going to be anything other than an estimate. So it's something you have to actually think very hard about. For more serious offenses, the Major Crimes Act that Judge Leeds discussed, you're looking at probably going to federal court. So murder is probably going to be filed in federal court. I've not seen that ever go to the tribe. It has historically, but not recently that I know of. Sex crimes are probably going to go to the feds. Robbery is probably going to go to the feds. Your more minor offenses are going to go to the tribe. The tribes are taking different approaches. I have seen the tribes, some tribes in particular, file cases where the individual's been in drug court for a couple of years, and it's a very old case. That one shocked me. I would have thought that the client would have probably been pretty safe to assume it would not be refiled. So there's no given here. There's always a risk. It's just whether that risk is great or small. And talking to your attorney that's assigned to your case, they're going to be able to give you the best guess, but it's always going to be a guess. Something that you should think about is how close are you to discharge? Are you going to discharge this sentence very soon? If you are, it might be something where you just want to let sleeping dogs lie and you don't want to mess with it. Another thing to think about is the statute of limitations. So for people who have already been convicted and you're serving time, generally in federal court, you're looking at a statute of limitations for 5 years. That does not apply to murder. That does not apply to child sex offenses. There are some very uncommon crimes that also have enhanced statute of limitations. But if it's over 5 years from the date of offense and it doesn't fall in one of those exceptions, it's very unlikely that the feds are going to be able to prosecute that. Again, that's something you should absolutely discuss with your attorney. So what is a McGirt motion? What does that mean? What does it do? There are really two separate categories of McGirt motions. There is a motion to dismiss for a pending case, a case that's pre-conviction. So that would apply to people who have been arrested and charged but have not yet been found guilty. It would also apply to people who have pled guilty and they're serving a deferred sentence, because with the deferred sentence, the court withholds a finding of guilt. You are not yet found guilty. You are not yet convicted. So those motions to dismiss those are typically being handled pretty quickly, pretty easily. If you can, in Tulsa County, if you can prove that you were an enrolled tribal member on the date of your offense, the state of Oklahoma is not fighting that. They will sign an agreed order to dismiss. I know in other counties it is probably different. If you're not an enrolled tribal member, expect a fight, but our judges are still granting some of those if you can prove your Indian status in one of those other ways. The other type of McGirt motion is post-conviction. So you have been found guilty already and you've received a sentence. And those are treated the same whether you are currently serving time, whether it's been discharged, whether you're still on probation, whether you're in drug court. If you have been found guilty, there's been a judgment and sentence, that is a post-conviction motion. Those cases, the state is fighting with every ounce of energy that they have. They are currently stayed under two decisions. The Attorney General's office has been, the Court of Criminal Appeals in, I think it was March 16th, maybe, decided the Sean Bossy case, and they vacated his conviction in a death penalty case. The Ryder case followed. I'm not sure that they've actually taken action on any after that. But the state of Oklahoma filed a petition for rehearing. That rehearing was denied. They filed a motion to recall the mandate pending their seeking cert with the Court of United States Supreme Court. There were oral arguments on that. The Court of Criminal Appeals did impose a 45-day stay. The United States Supreme Court then on May 26th imposed an indefinite stay in the Bossy case until either the state fails to perfect cert is denied, or the issue is disposed of. So that stay involves all post-conviction cases. That is very confusing to people because Mr. Bossy himself was a non-Indian. He was a non-native. It was the victims in that case who were native. That is confusing to defendants who are native. They think that that does not apply to them. Well, that's only one part of the Bossy decision. So the Bossy decision, they're appealing two issues. One, they are arguing that the state has Crimes Act is implicated and it involves the victims. So that is one part. They are arguing that for victim native crimes, the state has jurisdiction that's concurrent. But the other issue is whether or not the issue can be waived. So for individuals who did not raise the issue on direct appeal or did not raise it, prior to recently, whether or not the law allows them to raise it now, and whether or not the fair doctrine of fairness latches would prevent them from raising it now. So Bossy, that stay, it does apply to everyone, contrary to what people think. The second decision is Wallace. So that decision is at the Court of Criminal Appeals, and that is where the Oklahoma Court of Criminal Appeals has asked the parties to brief whether or not McGirt should be applied retroactively. So that is a complex legal issue. It deals with substantive versus procedural and a lot of things that we don't need to get into, but the state is advocating that convictions that were final, so you have been sentenced when McGirt was decided July 7th, I think, or 9th of 2020, whether or not it's going to start from that point forward and only be applied from that point forward, or whether or not it's going to apply to cases in the past. So that, again, is an argument that is going to apply whether or not the defendant or the victim is native. It's going to apply to pretty much everyone whose conviction was final when McGirt was decided. So those post-conviction relief applications are much more complicated at this point. They are something that every district attorney I'm aware of is fighting, taking the lead from the Attorney General's office. They are stayed by the Court of Criminal Appeals. If you happen to have one granted, at least in Tulsa County, they're immediately appealing it. The Court of Criminal Appeals is pretty much immediately staying it. So we're all just waiting on those two decisions. One may solve it, one may not, depending on how it lands. In Bossy, the state's cert application is due, by my count, September 7th, and we'll see. It typically takes 1 to 2 months for the U.S. Supreme Court to say whether or not they'll accept cert. And if they deny cert, that's good news for defendants. That could be, October at the earliest, I would say. Wallace, it's fully briefed. The Court of Criminal Appeals, it's in their hands. I don't know if they'll do oral arguments or what, but we're just waiting for word from them. So those are two separate issues, pending cases, post-conviction, treated very differently. One's relatively easy, one is not. So what happens once a McGirt motion is granted? So again, this is going to differ county by county, but our prosecutors are working very closely with tribal prosecutors who are working very closely with assistant U.S. attorneys. Basically, before our DA even signs an agreed order, they have already referred it to the feds in the tribe. In practice, they're unwilling to sign an agreed order, even if they know that they should, until they've made that referral. The feds and the tribes are working together as well. When Hogner came down and it was decided in March that Cherokee was also treated the same way as the Creek Reservation. We had, hundreds of cases here in Tulsa County that had been on hold pending that. And Rogers County the same. I know they had headlines based on the amount of cases that were pending. Myself and the prosecutor and the judge had a meeting, like, I'm gonna sign these orders dismissing. I'll give you till, it was a Thursday, I'll give you till Monday, state, and all of these orders are getting signed. And the state immediately emailed the AUSA, the list that they had. I was then copied on an email from Cherokee Nation including AUSA, including the Tulsa County District Attorney, that had a list of all of the cases and where they were, filed by AUSA, filed by Cherokee Nation, deferring to AUSA. So all of these agencies are working very closely together to make sure that there is not a case that falls through the cracks, that they are getting pursued, at least from their end. Whether or not it actually gets filed, again, is going to be up to the tribes and the feds. I have seen the feds decline cases that shocked me. I have seen the tribe that take up cases that shocked me. So there's really no telling exactly where you will end up. Most people, when your case gets dismissed, most of my clients are getting released from Tulsa County Jail. So in the rare case with the more serious offense, there's a federal hold being placed. Sometimes there's a tribal hold being placed, but for the most part, they are getting released. They may then later get notified that charges are being filed. When Hogner came down, Cherokee sent me an entire list. We are filing charges on these people. We are giving them the following dates to report to our court. If they don't report on one of these dates, we're going to issue a warrant. So you can expect either dismissal and that's it. You can expect to get released, or you can expect to get transferred to another jurisdiction. A couple of things to think about if your case does get dismissed in state court. You want to make sure it should be dismissed cost to state. All Tulsa County cases are being dismissed cost to state. You should not have to pay costs on a case that is being filed in an improper jurisdiction. The clerk's office, now they're not always taking those costs out. So one thing that you want to do as a defendant or a family member of a defendant is you want to make sure that you go to the cost administrator. Here, it's on the second floor of the Tulsa County Courthouse. Bring a copy of your order dismissing. If you don't have it, it's probably scanned in. It should say cost to state on the order. It should say cost to state in the minute. Those costs need to be wiped away. You do not owe those. You do not want a failure to pay warrant going out for costs you should not be responsible for. You can also theoretically file a motion to expunge that. I do not file those motions, but it is my understanding that you can expunge a case that is not going to be refiled by the state or cannot be refiled. Well, in this case, if it's been dismissed for lack of jurisdiction, I think the state will concede that they're not going to refile that. So you should be able to request to expunge that, but that's an affirmative step that the defendant must take. That is not something that is automatic. For post-conviction relief applications, none of those are getting granted at this point that I'm aware of. But if they are granted, they're almost immediately appealed and then stayed. However, if at some point they're granted, those same things apply. Make sure your costs are wiped. You can file to have it expunged. Those are things that you should think about. And then the final question from Colleen: has McGirt created chaos in Oklahoma's criminal legal system? That is a loaded question. I would say that change is always hard, and it was bumpy in the beginning, but it did not take long to settle out. So when Tulsa police, I've read more police reports than I can count. When Tulsa police arrest someone, they ask them if they're native. The probable cause affidavit almost always says, ask defendant if he's native. He said no, or something like that. They will then either book the individual in on state charges, or they might book the defendant in and there will be a tribal hold placed. So the cops are figuring it out. The courts are figuring it out. If someone is coming back through bond docket and they know that this person is confirmed native, they're PRing that person out. They're letting them out without having to post a bond. They're setting that person on a McGirt court date to have that case most likely dismissed. For misdemeanors and pre-prelim cases, every Wednesday at 1:30 in the Tulsa County Courthouse, there is a docket where these cases are getting disposed of. So it did not take long for a system to get put in place, and it is rather smooth. They are almost always getting agreed to. Post convictions are almost always getting continued. We figured things out. And if you read the McGirt opinion, Justice Gorsuch says there's an obvious solution to this proposed chaos, and it's shifting personnel. There will be more federal prosecutors. There will be more tribal prosecutors and tribal judges. There will be, maybe tribal prosecutions that didn't exist before. You don't have to be a genius to figure that out. There might be less state cases and more cases in the other systems. But the feds and the tribe have both said they are up to the challenge. And I think they've proven that they can take on that challenge. Like the question in the comments, Mr. McGirt was retried and found guilty. It was not chaos. It all worked out. What is contributing to the perceived chaos, in my opinion, is the state's response to this. All counties are different, like I said, but there does seem to be a death grip by the state actors, the Attorney General's office, the district attorneys, the governor, on cases that were formerly thought to be state jurisdiction cases. They do not want to let them go. And they are crying victims' rights. And in my opinion, that's a big red herring. It seems to be a little bit of an ignorant position to me to take, that no one can protect these victims like we can. No one can protect these victims as well as we can. I don't think that's true. I think the feds are more than willing to take up cases. The tribe is more than willing to take up cases, and they are filing cases. They are dedicating money to these systems. They are hiring prosecutors. They are hiring judges. They are building new complexes. They are dedicated to doing the same thing in a different system. And in fact, I would say some statistics suggest that victims might be better off in those systems. In 2020, when you look at the felony domestic assault and battery cases that were filed in Tulsa County, 77% of those cases were dismissed. 77% of felony domestic assault and battery in Tulsa County were dismissed in 2020. So to say no one can do it as well as we can, these victims are not going to get a fair shake, I think is not accurate. And with post-conviction cases, they're warning this danger of loss of evidence and loss of memory, and we can't retry these cases. We're not going to be able to. That may be true in a very small number of cases. But again, Mr. McGirt retried, convicted, and he's not the only one. A number of people have been retried and convicted. Almost all of my PCRs that have been granted, they have federal attorneys that are reaching out to me. They are being retried. Those cases are being prosecuted. And if that's truly the concern for a number of these people, it's been almost a year, even longer than that. Some people filed post-conviction when Murphy was decided in 2017, and they still don't have an answer on that post-conviction because of the fight that the Attorney General's office is putting up. So if you're truly concerned about loss of evidence, loss of memory, the ability to re-prosecute, you've had 4 years to file these charges and file this case, and you haven't. So it is not chaos. The tribe and the feds are more than qualified to pursue these cases. The cause of this perceived chaos, in my opinion, seems to be the state's reaction to the decision. And thank you.
That's great. I love the practical context. I love helping folks who are on the webinar who might be family members and friends of people who are incarcerated that have been wrongly incarcerated under the new rulings. And so that's super, super helpful. I don't think there's I haven't seen a lot of places where people can get this information. So I'm really grateful for all of that. We have one more panelist. I want to make sure and give him some time. It's really, really important for Oklahomans for Criminal Justice Reform to allow and lift up the voices of people with lived experience. And Mr. Fennell is here with us today. He is a veteran, and he has served time in Oklahoma DOC, and he's also a Cherokee citizen. And I'm gonna ask you some questions, Mr. Fennell, so you don't have to feel like you have to give a big statement if you don't want to, but also if you have anything you want to say, feel free to go ahead with that. But my first question is just, can you give us sort of an overall idea of what your time in the Department of Corrections was like?
What my overall experience? Worst experience of my life. But I will tell you that in my case, I had a easier time being in prison because going to prison saved my life. I had about a 40-year history starting in the military right at the end of Vietnam of drug usage, and I had a 40-year career. I was physically on the verge of dying when I got busted, and so it made it easier for me to do my time because I was very happy that I was able to have a chance to live. And overall, it's a terrible place to be. It's you're just doing time. I mean, it's your time. You're just counting the minutes and the days and the time, and try to make the best of it. Do is try to stay healthy and exercise the best you can, and take advantage of any programs if there's some that apply to you. I wasn't recommended to take any programs. I quit doing drugs in prison. I been clean for 3 years. I spent 40 years doing them, and but I've got 3 years clean under me right now. I haven't had to drink alcohol in almost 5 years. And I turned to a higher power when I was in there, reestablished that connection, and felt like I got help during the whole deal. There were some times when I felt like my life might not. There's a lot of violence, a lot of drugs. I was me being a drug user for 40 years, I was kind of shocked at the availability of drugs in prison. They're rampant, and there's a lot of use. And so I feel proud that I was able to not use them in there, especially after my history. But there's a lot of drugs, and there's the culture of violence. It's and thank God it isn't an every day, every minute thing, but there were times, luckily, my age, you get a free pass if you're old enough, kind of. Guys told me one time in prison, they don't get cool points for beating up old guys. And that free pass kind of came in handy a few times. Yeah, I just try to stay invisible, to stay out of the way. And I don't have a lot of other things to say about it. It was effective. It did it for me, but for a bunch of guys, it's not going to. There's going to be a bunch of guys that are, if they get out on parole like me, they're going to struggle so hard that I fear they will go back to prison. They'll end up back in there because it's a tough road. But I'm happy to have the chance.
We're so glad to have you back out on the other side. Have you, since you've been listening today, and I know you're a citizen of the Cherokee Nation, has McGirt or reaffirming the sovereignty had any impact on you, or what are your thoughts? Do you have any thoughts about that?
I've so little thoughts. I have to kind of give you background. I was always proud that my grandfather was half Cherokee, but I never had anything to do with Cherokee Nation until at a midterm of my life in my 30s or somewhere in there. My brother got his Indian cards, and my mother did too, and they started using the Indian healthcare. Most of my health needs were covered by the veterans, by the VA, so I didn't need the Indian healthcare, and I didn't have very many needs that I knew of, to have anything to do with it. It wasn't until I was 60 years old, that's 6 years ago, that I went and got my cards. I went to over by Claremore and got my cards. Never used them. I thought I would if I needed to or whatever. They were in my billfold when I got busted, so I lost those cards. I refiled. I got them back in prison. They let me file paperwork, and I got my cards back. I wasn't when they ask you when you go into prison, what are you? Well, as far as I was concerned, I was a white boy. I mean, just a white guy, and I knew I had Cherokee blood and I was proud of it. I had a heritage and everything, but I didn't, I wasn't a flag waver or anything, I didn't go around talking about it much or anything. It just didn't have a lot to do with me. I answered that I was just a Caucasian. Well, and I'm not knowing much about what is getting, what I'm getting into here, what's going to happen or whatever. But when I got in, I knew that it didn't take me long to realize that I kind of just wanted to be independent of everybody and try to be off to the side and not involved in much of anything. I thought maybe I'd make it out of there alive if I could just be invisible. And I didn't acknowledge, and only if asked, and if asked, I would try to explain. I would be asked by some other Cherokee and other Indian fellows in there. And I would just try to evade the issue because, sad to say, and I don't know if it's the culture of growing up or what, very violent. The Indians are like a gang in prison, and they need to be. They take care of themselves. But if you want to be in their group, you're going to have to be initiated. And in my age, I knew what the initiation was, and I didn't want to be involved in that. I didn't want to be involved in violence. Mm-hmm. But overall, I'd say they in their raising, or I'm not an expert. I just think that I have a kind of a culture of standing up for yourself, and somebody doesn't step on your toes, or they're going to get it. But I saw quite a bit of violence. Initiations, I saw a guy get his nose broke. 5 or 6 guys. If you want to be part of their guys, but there's a payoff to being part of their guys. You got somebody messing with you, you got the whole Indian nation behind you, But I didn't feel like I needed that because I was just trying to do my time and get out of there. But and there's a lot of good Indian guys too, and everything. But sorry.
So post incarceration as well, your involvement with
my involvement. Oh, by the way, my involvement now. I did find out while I was in there that a couple guys told me, "Hey, man, you're Cherokee. You should. There's reintegration programs." So I started investigating that as soon as I got out, and I did find out. And the one thing about guys getting out on parole and stuff, the one thing they're missing that I wish that somehow, some way they could get is just some kind of cash. There is help getting clothes, and there's help with maybe some transportation issues and stuff. But man, you're not going to have much money, and it is going to be really tough. I got lucky. I got the stimulus of all things. I got a stimulus 2 weeks before I got out. I couldn't believe it. I would have never dreamed it. But anyway, I did get, I went out and they bought me some clothes at the Catoosa Walmart. I haven't had that. And then after all these years, I got the stimulus money that they just gave out, the $2,000, which I desperately needed. And might get a bonus here for being vaccinated. They're possibly going to give out some money for I filled out the paperwork for that. And I mean, I welcome any dollar I can get because I'm using it for good cause. It's not being spent unwisely. But I haven't had a whole lot, of to do with it. I am investigating the possibility of getting help with rent, and I understand I can. I think I haven't contacted them yet, but I might get some subsidizing on getting a place to live. I live with my brother currently, but I think I probably want to move into a place of my own. I hope that was an answer.
Thank you so much, Mr. Fennell. We're going to take some questions from everybody. There's a ton of questions, and I know Judge Leeds, you said you've got to run, so thank you so much for everything. And if anybody has questions, we'll follow up and get those answered from you. So thank you so much. If any, do you guys have a few minutes to stay, Casey and Mary, or do you have to run?
I have just a couple minutes, but
Okay.
yeah, I do have another meeting that I scheduled. So unfortunately, I have just a couple seconds here.
No, you're good. I booked us until 1:15, so it's about 4 minutes. There's been so many good questions here. Do you have, Casey? Go ahead. I was going to ask you the grounds for expungement, since there's not an explicit grounds in the statute.
So that's not a question that I can answer, but I've asked, so my office is starting and it's not within my office. It's funded outside of my office, but they're tied to our office. They're starting kind of an expungement project. And it's their belief that because the state will be unable to refile or will not refile, that these dismissals will be eligible. I cannot speak to personal knowledge on whether or not they are legally eligible, but I can tell you that an attorney who knows more than me thinks that they are. I'll also answer this question in the comments, which direct appeal, the waiver arguments in the Bossy case are not going to apply to direct appeal. So the Bossy case deals with people who did not raise this issue on direct appeal. So if you raise this issue, once you're convicted, you have the right to direct appeal. You have to file notice of intent to appeal in appropriate time or get an exception for that, and then you appeal your conviction to the Court of Criminal Appeals. If you raise this issue in your direct appeal, then it is not waived under the arguments that the state is claiming it will be waived in Bossy. As long as it is post-McGirt, July 2020, the Wallace case should not affect that either. So if you raise this issue on direct appeal, what is typically happening is, unless there was a hearing at the district court level, the Court of Criminal Appeals is remanding it for a hearing to be held. The district court then makes findings of fact and conclusions of law, either saying, yes, this person does qualify as Indian and this crime did occur on Indian land, and for that reason, the case should be dismissed. Or they may say, we do not believe this person qualifies as Indian, or we do not believe that this is Indian land because the reservation has been disestablished or did not exist. Then that gets sent to the Court of Criminal Appeals. In large part, these are all being worked out well. The AG's office, the local district attorneys, they are conceding Indian status for enrolled tribal members. They are sometimes even conceding it for non-enrolled tribal members, like the Coulee case, which someone posed in the questions. And the OCCA, I have only ever seen them adopt the district court's findings of fact and conclusions of law. I have never seen them come out on a different way on a direct appeal case. So those cases are getting dismissed. People in prison who are getting released because of McGirt, unless it's outside of Tulsa County and post-conviction is getting granted, it's because it's a direct appeal, and so it was not waived.
Perfect. And then there was a small question, Mary, maybe you can speak to this, on whether some of the other tribes other than the 5 major tribes will qualify under the McGirt line of cases.
I think the answer is yes. I think there are other tribes in Oklahoma who are contesting the idea that their reservation was ever disestablished by Congress. We have yet to get definitive answers on that from the Oklahoma or federal courts. But, I will just say, speaking as Mary Catherine Nagel, not as an attorney for the Osage Nation or Quapaw Nation or any of the other tribes in Oklahoma, if you go read, for instance, the 10th Circuit's decision in Irby from 2010, which is concerning the Osage Reservation, none of the court's findings in that decision hold up post McGirt. I mean, the 10th Circuit in 2010 basically said, it's true Congress didn't disestablish the Osage Nation's reservation, but they probably meant to, which was Oklahoma's argument in McGirt, which the Supreme Court shot down, again, deferring to separation of powers and saying that's not the business of the federal courts. That is for Congress and Congress alone to do. And so I don't know how Irby is still good law today after McGirt. And I think, again, that's just an issue that will have to be worked out either through legislation in Congress to affirm that the reservations for other tribes still exist, or in different appeals that could go before the Oklahoma Court of Criminal Appeals or a decision in a federal court. And so I think there very much are other tribes that still have we know there are tribes that still have reservations in Oklahoma.
Great. Well, it's 1:15. I know we didn't get to all the questions. If anyone did have a question that didn't get answered, please email it to me. It's Colleen, COLLEEN, at okjusticereform.org, and I will get your questions answered in text. I just can't express my gratitude enough to our panelists today. And I know this is a very evolving issue and lots of things to think about and practical applications of this. So maybe we'll revisit this panel in a couple of years and see where we're at with everything. But I'm really grateful to all of you. And so thank you so much. And we will see you soon.
Thank you so much.